Alright, guys, buckle up, because this video wastes no time setting the stage for chaos. Right out of the gate, we're told this courtroom saga involves sovereign citizens, wild legal theories, and a driver who allegedly thought smoking weed behind the wheel, with kids in the car, was no big deal. The narrator frames this as more than just a traffic case, it's a preview of entitlement colliding with reality. You already know this won't end well, and that tension hooks you instantly. This short intro does exactly what it should. Signals stupidity, confidence, and consequences are about to meet.
42. The defendant is Ms. Jasenia Amber Raby. Ms. Raby appears today via WebEx. Ms. Raby, ma'am, it's Judge Murphy here. Can you hear me okay?
Yes, Your Honor.
Terrific. All right. And thank you very much for your appearance today. I hope you didn't get as much rain as we got overnight. So you probably were going to be in worse shape trying to navigate the roads today. But
fully completely washed out. So
well, I'm sorry to hear that. Okay, so let me just give you an overview of kind of the way this works, because since you're representing yourself, let's just start with that question. Are you comfortable continuing to represent yourself or for purposes of this hearing as well?
yes.
Well, I'm sorry, was that a yes?
Yes, sir.
All right, thank you, ma'am. All right, so the procedural history here is that on August 5th, 2025, when you appeared personally, you submitted to the court a lawful challenge to jurisdiction, standing, and authority, as well as an additional, that's a 2-page document, and then an additional 3-page document that was entitled Affidavit of Standing and Rebuttal of Jurisdiction. So generally speaking, the party who makes a motion goes first and argues his or her assertions. You don't have to, if you want to just stand on the pleading, that's what we call it. If you want to just say everything in writing is all I have to say, you can do that. But I want to give you the opportunity first to be able to run through the various points that you have. Then the people, and Mr. Bama is here on behalf of the people of the state of Colorado, the people will offer their position as to your arguments, and then ultimately I'll have to make findings and then either grant or deny your motion. So with that said, did you want to go ahead and begin with anything you want to state?
Everything I have to say.
Alright, guys, this is where the courtroom chessboard gets set. The judge calmly opens the hearing, confirms the defendant's identity, and patiently explains the process, especially since she's chosen to represent herself. That decision alone raises red flags. The judge's tone is professional, almost gentle, but there's an underlying sense that he's already seen this movie before. You can feel the imbalance forming, one side grounded in procedure and law, the other relying on paperwork and beliefs. This moment quietly establishes who actually has control in this room.
To this motion.
Yes, Your Honor, we have argument that we do have a witness. Caitlin Bills is on WebEx.
Okay. All right.
Intend to call her briefly.
All right. Very good. Do you want me to swear her in?
Yes,
now?
please.
Okay. Deputy Bills, ma'am, good afternoon. Are you able to unmute yourself and switch on your camera?
Yes, sir. Sorry, I'm trying to get my camera on.
No problem. I know it's a little cumbersome, so thank you very much for your appearance and your getting the WebEx machine thing to work.
Yeah.
Okay to myself?
Yeah, you can mute yourself. If you want to say something, just raise your hand and get my attention, and and you'll have an opportunity, Ms. Raby, to cross-examine Deputy Bills. So what'll happen is I'm assuming Mr. Bama is going to walk through some direct testimony or solicit some of her direct testimony, and then you'll have a chance to cross-examine her. You can ask her questions about what she said during the course of her testimony. You don't have to, but that's your right. All right. Good afternoon, Deputy Bills. Nice to see you. Could you please swear or affirm under penalties of perjury that the information, that any testimony you're going to give today is the truth, the whole truth, and nothing but the truth?
I swear.
Okay, very good. Thank you, ma'am. All right, Mr. Bamus, sir.
Thanks. It's okay if I stay seated?
Yeah,
Okay.
stay seated. There's no
Okay.
formality required.
All right, state your name, please.
Caitlin Bills.
And were you employed as of 4/29/25?
Yes, as a corporal with the San Miguel Sheriff's Office.
And did you receive information about a traffic complaint when you were on shift?
Yes, sir.
And do you recall how you received that information?
Via San Miguel County Dispatch over the radio.
And what information did you receive?
Information about a black Jeep Wrangler or Rubicon Jeep that had a pink crown in the back window with temporary plates that was going a slow amount of speed on Highway 145, 1 mile marker 19, and that was failing to maintain a single lane as the vehicle was driving towards Norwood.
Mr. Adams was concerned, well, what was he concerned about when he made the call?
The driving behavior of the Jeep and the fact that it was going slow and failing to maintain lane. While also when he had passed that vehicle, he had smelled marijuana and seen the driver smoking what looked like a marijuana cigarette or something along those lines to him.
Mr. Adams had to actually pass this vehicle in San Miguel County to get around safely.
Yes, and he also had to hit his brakes because the vehicle was going so slow, so it impeded his traffic when he was trying to drive and his safety as well.
Okay. Eventually, did you come in contact with the Wrangler?
I did in the town of Norwood on Grand Avenue.
Why did you initiate a traffic stop?
I had seen the Jeep Wranglers stopped at a stop sign on Grand Avenue in North Pine, and it had sat there for an extended period of time. Then quickly
All right, guys, here's the first real warning sign for the defendant. When invited to explain her jurisdiction challenge, she flatly refuses to speak, insisting everything is in writing. That choice sucks the air out of the room. Instead of clarifying or persuading, she shuts down entirely, handing the momentum to the prosecution. The judge gives her every opportunity to engage, and she declines each one. This isn't confidence, it's avoidance. You can almost hear the legal clock ticking as her strategy collapses before it even starts.
Car with the defendant at the time of the stop.
yes, her mother-in-law was the passenger, and then she had 3 young children in the back seat.
And eventually, you do have a conversation with the defendant, and I'll say that that's beyond the scope of what we're talking about today, but just to kind of paint the complete picture, you have a conversation with the defendant, and then is she ultimately charged with driving under the influence of drugs?
Yes, sir.
Okay. And did she consent to any tests?
Yes, she consented to voluntary roadside maneuvers.
And how about any chemical testing?
Yes, she consented to a chemical test of her blood. And when she consented, she said that there would be THC in her blood.
Okay. And what else did she tell you anything else when you were conducting your investigation?
She had told me that she had smoked marijuana. It had been outside of her car. And this was after she initially had lied to me about that she hadn't smoked at all, and she changed her story. But she had pulled over and she had smoked outside the car, and it had only been 1 joint, even though the car smelled like burnt marijuana on the inside, and there was burnt marijuana cigarettes that were visible in the ashtray.
Okay. For the purposes of this hearing, those are all the questions that I have.
So, Ms. Raby, this is now your opportunity to cross-examine Deputy Bills about anything that she offered as testimony. If you'd like to do that, you're welcome to go ahead. You don't have to do it, but it's your right.
I don't have any questions to cross-examine.
All right, guys, this is where theory meets reality. The prosecution calls deputy bills, and suddenly the abstract arguments about jurisdiction don't matter as much. The officer is sworn in, the rules are explained, and the judge reminds the defendant she has the right to cross-examine. Everything shifts from paperwork to people. This transition is
Working with the WebEx machine as well. Okay.
Yeah, sorry about that. Have a good day.
No worries. Okay. Do the people have further argument or evidence or presentation?
No further evidence, ready to make argument. I don't know if I think just for protocol,
Ms.
I'm gonna
Raby.
open up to Miss Raby first.
Yeah. So did you want to, Ms. Raby, this is the time when you can make effectively what would be a closing argument, a summary of what your assertions are in support of your motion. Again, you don't have to say a word, but if you wanted to offer a global overview of what you're advancing in your motion, you're welcome to do that. Do you wish to do anything like that?
No, everything that I have to say is going to be written to you in certified mail.
Mr. Bamasir, do the people wish to make
Yeah, thanks. In order to make a traffic stop, the police must have reasonable suspicion that a person has committed a traffic violation or other offense. Suspicion is reasonable when there is an articulable and specific basis in fact to support it. And the police must have specific and articulable facts or rational inferences from those facts, which would support a reasonable suspicion of criminal activity and thereby justify the intrusion into the defendant's personal activity. The reasonable suspicion here was articulated by Deputy Bills, and it started with a citizen informant, a ready report, if you will. And the ready report is something that has been dealt with in Colorado courts before, and they can serve to justify or create that reasonable suspicion. And I think in this specific case, that reliability is all the more established based on the fact that this was a trained law enforcement officer, albeit he was working for the jail at that time and not necessarily a patrol officer, but still law enforcement and still understands what's required when you're calling in a ready report. Also, peeling in front of the marijuana store and almost backing into Deputy Bills during the stop, again, that just leads to the reasonable suspicion for this stop. And the site that I'll have there is kind of the cumulative reasonable suspicion is People v. Garcia, 789 P2D 190192, Colorado.
All right, guys, this testimony is devastating. Deputy Bills lays out the citizen report: slow driving, lane violations, marijuana smoke, and a driver actively smoking while on the road. Then comes the kicker: children in the back seat.
All right, Ms. Raby. I just want to make sure that I, as fully as I can, address some of the points that you articulate in your written motion. And then I'll also I'll layer in the discussion that the people have highlighted here about the reasonable suspicion or lack thereof, et cetera. But I think I did, as part of the record during your last appearance, inform you that in any criminal case, including this one, that the court has authority over that case as a result of Article 6 of the Colorado Constitution, Sections 1 and 16, as well as a basis being Colorado Revised Statutes, Section 13-6-106. Further, that Article 6 of the Constitution, the Colorado Constitution, more specifically Section 17, does grant the court subject matter jurisdiction, meaning that this type of act, this type of case is is appropriate to be heard in the county court. In addition, that point is emphasized further by Colorado Revised Statutes 18-1-201 and Colorado Revised Statutes 13-6-106. I also noted for the record during your prior appearance, and will do so again today, that personal jurisdiction was in effect achieved or perfected as a result, first, of the issuance of the underlying summons and complaint, which was served to you by, I guess, Deputy Bills, yes, back on April 29th, 2025, during that traffic stop that was just discussed as part of her testimony. And then your personal appearance here on August 5th, 2025, also reaffirmed that personal jurisdiction, meaning I have authority over you as a person. I have authority over this case, given the subject matter of the case. And with that, I also want to draw your attention to my oath of office then, that was administered on the 8th of June, 2020 by District Court Judge D. Corey Jackson, as well as the State of Colorado Department of State having issued a certificate certifying, more specifically, the Secretary of State certified that on November 8th, 2022, that I, Sean Murphy, was duly retained as a county judge in the 2022 general election, that being the county judge for San Miguel County, Colorado. So let me turn then, with that background highlighted, to some of the assertions you make. Your document that's titled Lawful Challenge to Jurisdiction, Standing, and Authority, in which you say this is a lawful and peaceful demand for proof of proper jurisdictional standing. That I have just provided to you in terms of the county court's jurisdiction over this matter, more specifically subject matter, as well as you as a person, as well as my oath and retention certification. So therefore, that is proof of jurisdictional standard. You further provide, or you further request that we produce reasonable articulable suspicion, so also known as reasonable suspicion. So the people have addressed that in their argument, and the court, well, this is where we get into the ready report here. And as Mr. Bema has highlighted, that in this matter, in this particular case, there was this report from an off-duty San Miguel County deputy who did observe certain traffic violations, including the weaving, I suppose, as well as he had both seen and smelled the presence of marijuana emitted from the vehicle and seen you smoking what appeared to be a cigarette of some type. And so that information received from Corporal Nick Adams is something that what we call the totality of the circumstances has to be considered, as well as the circumstances surrounding what Deputy Bills observed directly that she just testified to. And so,
All right, guys, this is where the hole gets deeper. The officer testifies that the defendant consented to tests, admitted THC would be in her blood, and changed her story multiple times. Burnt marijuana was visible inside the car. And then, unbelievably, the defendant chooses not to cross-examine at all. That silence speaks louder than any argument she could have made. The evidence goes unchallenged, uncontested, and uncorrected. This moment feels less like a defense and more like surrender, whether she realizes it or not.
propose, how much time would the people like? Is a month sufficient time, or?
Less than that. I mean, we've made an offer, and I've discussed it with her at length
Okay.
before, and the conversation was the offer is going to expire if you go through with this hearing.
Mhm.
I'm willing to. I mean, I don't usually have that hard of a line on that, so I'm willing to talk with her still, but Otherwise, we're ready to go. I mean,
Okay, what if we came back in 2 weeks, October 28th at either 9:45 a.m. or 2 p.m. And then at that point, if that date and time, one of those times on that date would work for you, Ms. Raby, we would just be holding another what they call pretrial conference. And then there would be possible discussion of whether or not you were interested in taking that offer. And if you don't have to take the offer, it is your right, of course, to enter a plea of not guilty and to request a trial either to a judge or to a jury. And you can weigh those options between now and then as well as weigh the offer that you've received, and just let us know kind of where you stand at that point. Would that date and one of those times work for you, ma'am? October 28th, either at 9:45.
sorry, I think
she
she
froze.
was
Yeah.
still muted
Sorry about
there.
that.
Yeah.
Oh, I'm sorry, Ms. Raby. If you wanted to say something, can you unmute yourself?
Sorry, I didn't realize I still had myself muted.
No problem.
Yeah, October 28th should be totally fine. Can we do the 2:45?
2
Since I
o'clock.
have to get my kid to school.
All right, guys, the prosecution now tightens the legal noose. They walk through reasonable suspicion step by step, explaining how citizen reports, officer training, and corroborating observations legally justify the stop. This isn't emotional or dramatic, it's surgical. Case law, standards, and logic all align neatly. While the defendant leans on abstract claims, the state anchors everything in established precedent. By the end of this argument, it's clear the stop wasn't just reasonable, it was textbook lawful. The foundation is solid, and it's not cracking.
And let's turn to, I think it's either Jacinia or Yesinia Rabi. Miss Rabi, can you hear me okay?
Yes, sir.
Did I say your last name correctly?
Can you? Raby. And it's
Raby?
Jacina.
All right. This is case number 25M42. Ms. Raby appears on WebEx. Mr. Bema for the people. And let's do this the same way. Mr. Bema, any update?
Yes, we had a hearing the last time on Ms. Raby's motion to suppress. There was an order on the record that denied that motion. I made an offer prior to that hearing to Ms. Raby. The offer prior to the hearing was stated will be revoked if we go through the hearing. However, at the hearing, I noted that if she still wants to talk, I'm open to those discussions. We have not had a discussion since then, so I'm not sure if she still wants to have discussions or if she is at this point going to set for trial. And Ms. Raby, if we do set for trial, this isn't anything to be rude or anything along those lines, but if we set it, then I can't engage in any more offers because there's certain work that needs to be done as a result of trial getting set. So I guess I'll kind of punt it back to you to see if you want to discuss any further or if you are at this point satisfied and want to set it for trial, knowing that there will be no more offers if we set it.
If you would like to discuss everything that I've filed and stuff like that, I would be willing to happily to discuss that stuff with you.
All right, guys, this is the final dismantling. The judge methodically explains subject matter jurisdiction, personal jurisdiction, his oath of office, and his authority under the Colorado Constitution. He addresses every claim the defendant raised and rejects them one by one with calm precision. Then comes the decisive finding. Reasonable suspicion absolutely existed. No theatrics, no insults, just law applied.